Okay, with that, I am going to turn things over to Anna.
Good morning, everybody. I'm Anna Gettman, an escrow officer here at Chicago Title. I'm going to be reviewing the preliminary title report. Just a little quick rundown about myself. I have been in the business for 24 years, started as a receptionist and dabbled in actually the title department. I was a junior title officer per se, and then thought that escrow officer was my calling. So here I am teaching you how to read a title report. How awesome is that? Just a few little things. I do tend to speak a little quick at times. I try to be as detailed as possible. Just pop your questions into chat and our great sales team will go ahead and stop me, and I'm happy to answer questions along the way. We will have some time at the end, I believe, Jennifer, for more questions. Okay.
Yes, we will.
So having said that now, so we are on our way. What is a preliminary title report? A preliminary title report is the report that is generated when a escrow is opened for a specific property. Oftentimes in this day and age, people request their title report once they get that listing agreement signed. It is very important that you have that listing agreement signed before you request a title report, but we are happy to generate one once that is. So you know what you're dealing with at the time of obtaining a listing. You know that you're ordering it, you're getting all your goodies, and if there's any problems on the title report, you have some time, not too much in this market, I guess, but have a little bit of time to conquer those hurdles, if any. So the preliminary title report is an offer for Chicago Title to issue a policy of title insurance covering that particular property that you are handling the sale on. And so it's for the particular state and or interest of the land, subject to the stated exceptions. Exceptions are the things that are affected on the property, but we will go into that a little bit further down the road. So these exceptions those problems that I was just discussing could come up. And so the exceptions are, the first ones are the government ones, and then any voluntary liens will follow. But again, we'll go over that. The preliminary title report is a report for us to go through to see what is affected on the property and what will be insured on the property and what will not be insured and what we are insured against, and so forth. The new owner will obtain a title policy, and that title policy will reflect the governmental involuntary liens and voluntary liens that they are choosing to put throughout the transaction. Okay. It is not a title commitment. It is a preliminary title report, but it is our promise to you that this is what we're dealing with. Once we take care of what needs to be taken care of, we are promising you that we will issue a title policy to the parties involved, whether it's a owner's policy standalone or it's a owner's policy and a lender's policy together. It is important for all parties to review the preliminary title report. It is our job as escrow to make sure that we review every single item on that preliminary title report, to make sure that we've addressed everything that title has picked up of record. That's very important that you understand that terminology, of record. We do not know about any agreements or anything like that that has not been recorded with the county that the property is situated in. But it is our responsibility to review that preliminary title report. It's our responsibility to ask questions. What's this? What's that? Does your seller know that they have 3 mortgages on the property? Does the seller know that he has the solar is affecting the property? Does the seller know that we're gonna ask questions. But it's very important for you as an agent and lenders. I do want to stress lenders. It is important that you review that preliminary title report. So when we are asking those questions, you're understanding where we're coming from. You're understanding why we're asking those questions. It's important that you review the title report, because you may review the title report before we have a chance to, and you may have questions yourself. So,
littering against the law, and they encourage you not to dispose of trash on the side of the
Someone
road,
needs
let
to
it
mute,
fly out the
please.
window to find a proper receptacle. They also make another.
Okay, perfect. Sorry about that.
Sorry.
So it is very important that you do review that title report, and so you can understand and be familiar on what's going on in the transaction. So we have a little bit of delay because we are at a mercy of a third party. You understand why and where it's coming from. Okay. The types of title policies, as I mentioned before, there is two policies. There could be a standalone owner's policy, which is issued on a cash transaction. So we get the question a lot where the seller said, I already bought a title policy. I don't need to purchase another one. I'm selling the property. They can just have the one that I bought. Well, it doesn't really work that way. So a title, we have to insure the new owner. So that seller got their title policy when they purchased the property, and that is their insurance that no one was going to come back from that previous owner and make a claim on that property, because their title policy insures them as that new owner. So in any escrow, we don't do escrows without issuing title insurance. We are not an escrow only type of company. We do title and escrow. So we will issue a owner's policy after closing to insure the new owner. There's various title policies that can be issued in a transaction. Various owner's title policies that can be issued in a transaction depending on what type of the property you are involved in and what it qualifies for. In your preliminary title report, towards the back of the report, describes each and every policy that is available. That particular property, we will, once we look. And then the second policy, there's title policy.
Anna, you're going in and out a little bit, so I don't know if you want to repeat what you just said. And now you're frozen.
Okay. Hold on one second. Can you hear me?
Yeah.
Yes.
Okay. I'm sorry. What was the last thing that you heard?
I don't remember, to be honest with you. Just whatever that last sentence or two that you said.
So the secondary policy that we would issue is a lender's title policy in a resale transaction. And that is if the buyer is obtaining financing to purchase a property, because their lender does require to be insured in the transaction. On a refi, the lender's policy would be itself its standalone policy. And basically, there's an Alta 2006 lender's policy that we issue to all institutional lenders. And I want to stress that because we do have private lenders, we have private money, we have seller carrybacks where they are acting as the lender. They do not qualify for an institutional Alta 2006 policy because they're not an institution and it's a different type of insurance. But they will be insured as a lender as a joint protection, and it's just like a piggyback extra policy off of the owner's policy, and so they will be insured as a lender. Okay. The matters that are shown on the report are as follows: the estate of interest covered, basically your fee simple or leasehold. You're very rarely going to see a leasehold preliminary estate holding. It's more of on commercial properties. If they are having a commercial transaction, you'll see a leasehold on there, but most of your transactions that you're going to be dealing with is going to be a fee simple, meaning they own the property outright. What's number 3 here? And then it's also going to cover the description, like what kind of land that is being insured. if it's a, vacant, if it's a single family residence, if it's a PUD, which is a planned unit development, or if it's a condominium. So those are the basic properties that will be covered in the preliminary title report and described with their associated legal descriptions. And then the exceptions, liens, encumbrances, and other risks, which will not be insured through the title policy. Those are the items that we're going to be asking questions about if we are not given the information for, meaning if we are told there's one mortgage and there's other items that come up, if a HERO loan comes up, if solar comes up, we need to get those taken care of. Because if it's a finance transaction, the lender is going to be asking those questions anyways. So, and then other requirements and provisions which are reflected as notes. The note section is per se the communication from title to escrow. It's title's message to us saying, here's the rundown of what we have found that you need to think about, ask about. A lot of there's two main important notes in the note section that I find that come up quite often, especially with finance transactions. The lender is very interested in the fact of what the type of land, like if we are showing it to be the same thing that they are told that it to be from the customer and the appraiser. So there's a note section that we'll talk about if it's a single family, like I just was describing, if it's vacant land, ag, if it's a PUD, planned unit development, or condominium. And then another note section that's in that note is if it's called a 24-month chain. You'll hear that a lot being asked from the lender saying we need a 24-month chain. Most times in the state of California, you are not going to have that problem, but every so often, if you have a lender out of the state of California, they are not familiar with our preliminary title reports for whatever reason, and they specifically ask for a 24-month chain, thinking it's a separate report. It is not a separate report. It's something that we include in every and all prelims that we generate. And so your 24-month chain will be in the notes section all the times. And so it'll be the note. And if there's no transactions, meaning then the last 24 months, that's what the 24-month chain means, is what has taken place in the last 24 months of record that has had any vesting changes. It'll say no activity in the last 24 months. Or if there has been activity in the last 24 months, it'll list the grant deeds that have been recorded to change title in that section. And then the last of the preliminary title report would be your assessor's parcel map. I'm going to go over this a little later because there's a few things that I do want to point out on the map that are very important that do go hand in hand with lender requirements. So we'll go over that once the map is up on the screen. This is our title page. This just talks about who, that we're Chicago Title, and then it also outlines the paragraph that specifically specifies that no liability is ever assumed under a preliminary title report, and further indicates what should be requested if the customer desires assumption of liability prior to policy insurance. Our preliminary title report is good for everything that, like I said, of record. We cannot know if there's any unrecorded leases, unrecorded deeds of trust where someone took a private loan and said, hey, I'm putting it.
Goes again.
We don't know anything about it. Okay, can you hear me?
Now we can.
Okay, sorry. I don't know, maybe when I lean back, if something happens.
Anna, Dave has a quick question of, are you seeing a lot of HERO loans still?
Absolutely. They're not new. They're back from 2018. 2018 must have been a big year for HERO for whatever reason. But yes, people that just bought their house, especially now because of the way the market is, people have a lot of equity even when they bought their house in 2018, or they did a HERO, I don't know what it is, but people are wanting to sell their house, and capitalize on what's happening right now. And we're seeing a lot of heroes from 2018, but yes, we are. Okay, this is the informational overview of the preliminary title report. It kind of tells you who, the specifics of the escrow officer, specifics of the escrow number, contact information for the escrow officer. And to the left, it would be the specifics for the title officer. And if it was a out of county, if we were handling the transaction here in Fresno, but the property was in Madera, that is considered out of county, even though we're neighboring cities and counties, and it would have a different escrow, it would have a different title number from the escrow number. So sometimes people will refer to a title number that doesn't really match your escrow number, and that is the reason why. It's because they have to have their own tracking for their purpose of issuing the title policy under their number in their county. And then it'll outline the property address. This is very, very, very important that if you look at your preliminary title report, you see that this address matches your purchase contract and or your listing agreement and or the transaction that you're handling with the refinance. And the reason why I say this is because if there's any kind of discrepancy of what we're showing, we're human. We input data day in and day out. Same thing for title. There may be a typo. There may be a limit. There may be something missing. If it's avenue and there is no avenue, or if it's street. So it's very important that you take note that the address that we're reflecting matches the address that are on your, supporting documentation in your file. The effective date. So sometimes when people look at the preliminary title report and they're not familiar, they want an updated preliminary title report. They're like, you gave me something that's a few weeks old. I need something more current. And it's just because they're not familiar with how we search properties and how we search properties hand in hand with the county and their data that's available. Our plant date is approximately 2 weeks behind what the county is, the live recording, because there's no way for the county to get us that information any sooner, because they record all day, every day, day in, day out, and they are inputting the data as fast as they can. But it's always been, since the beginning of time, that's always been approximately 2 weeks behind that. The date of recording. So we're telling you that this preliminary title report, everything we're showing you in this preliminary title report is of record to that date. So we've searched this property, and everything that's been recorded up to April 1st, 2019 is what we have found that has been recorded. And if something was recorded on April 2nd, we're not going to know about it if we're, April 15th at the time. So hope that is clear. And then, as we stated before, the next section is what type of policies that this property qualifies for. Title is going to tell me, the escrow officer, hey, this property qualifies for the Alta Homeowners Policy Title Insurance of 2013. This is the highest and biggest policy that you can be provided for the transaction, but that doesn't mean that it's available to each and every transaction. And it all depends on where the property is located and the qualifications. So just as a rule of thumb, if a property is in a tract subdivision, most likely they're going to be qualifying for this type of policy. If the property is in a rural country area, it's not likely that they're going to be able to be issued this type of policy, but they will be issued an owner's policy, but it just depends. And then again, if you want to know the differences and what policy includes what, you will have that in the back of the preliminary title report that describes each and every policy and what is covered and what is not covered. And then again,
Anna, I actually learned something interesting when my son bought a house from his aunt, that a CLTA policy will normally be issued in those types of circumstances that we don't offer the Alta homeowners when it's between family members.
I did not know that either. That is, wow. I learned something new too. I actually learn every day. Doing this for 24 years, it doesn't mean I'm an expert. I learn every single day. And thank you, Jennifer, for sharing that. Now I can, you know, get that information out along the way. And then the next section is what I was talking about earlier, fee simple. This is where it states that they own the property outright. If there was a leasehold where they were leasing the property, or a condominium where there's a common area, but they still own the condo, but we have to disclose that there's a common area that other homeowners share. So that'll also be there in that section. The next section is the vesting. This whole report is very important for you to, to be familiar with, but vesting is super important because there's various situations, there's divorce situations, there's people that pass away situations, there's inheritance situations, there's just so many type of situations that you can possibly imagine. So if you are meeting with a seller, or you've met with the seller, and the seller is Linda Federico Johnson, and she says, I own this property, I want to sell it, I want to list it with you, yada, yada, yada. And you're like, great, you go ahead and you sign the listing agreement, and you ask for your preliminary title report, and we get it, and it says David Johnson and Linda Federico Johnson, husband and wife as joint tenants, but you only talk to Linda. You've got to pay attention, because you can't, Linda doesn't have the right to sell the property by herself because David's on title. And so you have to pay attention to this part, ask those questions to say, oh, Linda, I see that David's also on title. What is the situation? You got to just gently approach that situation, because David may have passed away, or Linda kicked David to the curb. You just never know. So, but you have to pay attention to this section, because we are telling you this is the legal owners of the property. So you may have a situation where somebody has passed away and they don't hold title as joint tenants, and you may think that you're going to have a 30-day escrow, yada yada, and you're not going to, because the transaction can't close without going through probate first. It's a whole nother class, but I'm just saying, pay attention to this section, that it matches who you listed the property with. Okay.
So we've gotten the question, which is better, a CLTA or an ALTA? And it's not so much better as covering more areas. So can you very quickly just talk about that difference?
Okay, it's not better. It's just like a tract home is more specific. There's very little, it's just clear lines. So we can say that we can insure this tract home with this policy because it's been researched before. We have a starter, we have this, we have that. So it's not better. It's just a little bit, it's like car insurance. If you have a newer car, you're going to get like a type of policy because it's a newer car, and the chances of it's going to be a little bit more expensive because it has all the bells and whistles, and the parts are going to be easier to get, whereas an older car, you get a different policy. It might be a little bit cheaper, but the parts are harder to get. So I know that's a far out analogy, but that's basically I can say is, when you go out to rural situations and you get a CLTA, there's a lot of different variations. There's water rights, mineral rights. There's all these other things that kind of take into play that we don't know, that we can say we can insure this, give you this insurance, that no one's going to have a claim on your property. It's just a different standard policy where you get into a subdivision, and that subdivision had a owner's policy when it was first subdivided type situation. And so there's a lot more information in the system of record to support issuing that title policy. I hope that's as clear as I can make it. As clear as mud, probably. Sorry. Oh, okay. So you're just, you're going.
Because we kind of talked about all of that without going through showing number 1, 2, 3, 4. So
Okay,
I
yeah,
didn't
that's
want to
fine.
repeat for everybody.
Fast forward that and just get to my legal description, and then I'll pick up from there. Oh, wait. Did it go too far for the legal
Do you want to
description?
go back?
Just real quick, it doesn't matter that it's pointing to that, but
There you go.
Okay, so the legal description, oftentimes it'll be on a separate page because most legal descriptions are very lengthy. But if it's not very lengthy, you'll see it at the bottom of this first page. But like I said, often it'll follow this first page. And real quick, that you see that it says for APN parcel number, just make sure that matches your contract. Make sure that we're not reporting, because there are often times where there's family members that own several different parcels and they're only selling off one of their parcels. And so the vesting definitely matches because the family owns multiple parcels, but they are selling only one. So make sure that this APN number matches your contract and we're not selling the wrong property. Okay, next page, Jen.
And we already talked about the escrow number, so I'm just going to go straight here.
Okay, and so this is your exception page, and this is what we're stating that we've searched this property, and these are the following items that affect this property. These are the exceptions, like all is well except these things. And so your first section will always be governmental liens. We like to say involuntary governmental liens because every single property has property taxes, whether you like it or not. And so our first section is we always disclose the upcoming year. The Fresno County has their taxes, most counties, but Fresno County has their taxes split into 2 different years. First installment is the latter half of 1 year, and the second installment is the beginning half of the next. So we always let you know that those taxes will affect this property. We don't know what they are yet, but they are for the year of, in this case, for example, this coming year will be 21-22. So we'll disclose that to you as item number 1. Item number 2 are the current taxes. So we're saying this at this moment in time, the first installment is this much, and it's due. It's actually due November 1st and late after December 10th. So this first installment, for example, is $1,427.63. If you pay this installment on December 11th, you will be charged an additional $142.76. So we are just disclosing to you that this affects the property taxes at the time. We may show that the first installment is paid and the second installment is due. If both are paid, you will not see this item in this section because we'll throw it down in the notes section. Still disclosing you those installment amounts, but saying, hey guys, they've been paid, we're good. The next section is a special or said property that if the property taxes have gone into default, have not been paid, we will disclose to you as an exception item that they are in default, and these are the items that need to be, or these are the amounts that need to be paid. If you're going to close on or before, or we try not to close on that date because the taxes have to be postmarked that date for the tax office to actually accept that amount. So if you're closing before April 30th, you would need to pay this amount. If you're closing before May 31st, you pay this amount. If we've exceeded May 31st, we will have to contact the tax office to get that new amount. And so supplemental taxes, these are pretty fun. I don't know if you guys have ever watched our Title Tip Tuesday with Robin. She's been really great about doing that almost every Tuesday, but for 2 weeks in a row, we did highlight taxes because they can be confusing at times. And so supplemental taxes can be issued for various reasons. There can be in a redevelopment type of situation or new construction, or transfer of the property. And especially now, because of all these offers coming in above asking, and we're going to see supplemental, these buyers are going to probably see a lot of supplemental taxes in the next 12 to 18 months. And so if you're a buyer's agent and you are lucky enough to get your offer accepted in this market, you need to let your buyers know that they're gonna get a supplemental tax bill that's not covered in their impound escrow account. Because the assessor's office is going to see, we've assessed this property at 150,000 back in 2015, and now it's sold for 250,000 in 2021. Well, guess what? They're going to see that transfer, and they're going to be like, oh yes, we're reassessing and we're issuing a supplemental tax bill. And it could, like I said, it can be issued 6 months after the transfer, 12 months, and as long as 18 months. That's a very good rule of thumb, even for new construction. If you're representing a buyer with that's purchasing a new construction, please let them know. Expect a supplemental tax bill, and that is because they need to close the gap from what their current taxes are to what the property is valued at to date and to that transfer date. Mello-Roos you'll find in your tax roll if it applies to that property that you are handling, and it'll also show up in your natural hazard disclosure. So you're getting double disclosed here, which is really good. So if your property has Mello-Roos, and there's a big in it, and it's in your natural hazard disclosure. So just review that, and then I'll mention it a little bit later. Your hyperlink prelim will also have any supporting documentation. So CC&Rs, covenants, conditions, and restrictions. This is basically what you can and cannot do on your property. Just a quick note, if you are dealing with an older home that was built way back, it may have some CC&Rs that has some disparaging language. We cannot change anything that's of record. It's once something records, it's recorded. And so unfortunately some CC&Rs does have that, but we will give a little bit of disclaimer saying that these CC&Rs may have some, unpleasant language, and it by no means is it anything that is enforced, because times have changed. So in HOA situations, following your CC&Rs, it'll show under, it won't have a separate exception, but under the CC&Rs, it'll show that this property is located within an HOA. It'll say who the HOA name is. The one thing that's very difficult for escrow is sometimes they change hands on who manages the HOA. So if you can just be your escrow officer's bestest friend of ever, ask your seller who manages their HOA, and then when you send that request for preliminary title report, just say, by the way, this is HOA and this is who manages it. So that would be great. I'm doing the little escrow officer shameless plugs because I'm just trying to help, make a smooth transaction here. Your next section is going to be easements. Any easements that are recorded on the property. It could be anywhere between access easements. So if you're handling a property in a rural area and the neighboring property uses or accesses their property through the property that you're handling, you're going to see that here, an access easement. And landscaping easements, utility easements. So those type of easements will be described here, if any. It doesn't mean that all and every property has easements. I just handled an escrow where they asked us for a color-coded plotted easement map, and title came back and said there's none to show. So don't be alarmed if you get a prelim that doesn't show any easements, because not every property has any. Not every property has any. Next section is voluntary liens. And voluntary liens means that somebody voluntarily put a lien on their property that's not governmental. And because we're going to talk about involuntary liens that are not government, but voluntary liens could be those here, the hero loans, deeds of trust, and solar. So this section, you're going to see any deeds of trust that are on record. If your seller says they only have one mortgage and you see two to three deeds of trust, we need to start asking questions. If you see a deed of trust that is dated, you know, in 1980-ish, 88, we might have a little bit of an issue because those all should be paid off, you know, most likely. And we have to research, and no matter what, we have to get that cleared up one way or the other. We have to get a reconveyance. Hopefully the beneficiary and or trustee is still around, and we are able to do a little bit of investigation and obtain a reconveyance or a substitute reconveyance if it's a private bendy and the trustee is no longer. If we are unable, or if the beneficiary is deceased and we are unable to locate any errors, we would have to go down the road of a bond. And of course, that is a whole nother animal, and it could take up to 45 plus days to get that cleared up after we made a determination that we are not able to contact the beneficiary of an old deed of trust, that your seller simply doesn't have any documentation proving that it's been paid off. So just to keep that in the back of your mind, if you see old deeds of trust, we need to jump on them like right away. And then solar, as I mentioned before, you will see if there's different types of solar. There is a power purchase plan where the panels they belong straight to the solar company, and the homeowner is just purchasing the power, or the homeowner is leasing the solar system. So there's just various types. I want to suggest that if you go on a listing agreement and you see panels on the roof, you ask right away, and we need to get that solar transfer process started right away. Please note, solar companies will not talk to escrow officers, assistants, until the seller has already initiated that process, provided them the buyer's information, and provided them the escrow information, because all that transfer process has to start and be well on its way before they even answer our email saying, hey, can we get a release from the solar agreement on the property? So please, please, please start that. As much as we would love to help you and get that done for you, a lot of the times there's a huge misconception that, oh, escrow is going to take care of it. And then we're a week out from closing, and I ask about the solar, and they're like, well, I don't know. And so it happens, but please just start that process if you see those panels, especially if, and then also too, I mean, the buyer's agents and the buyers ask those questions. There's panels, like, what can we do to get this taken care of? Like, let's jump on this. If they're owned, that's not a problem. No big deal. There's nothing to transfer. So there's that. And then financing statement can be anywhere from the actual solar company putting a financing statement on there to a private, or to a credit union. That's another misconception, is the seller will say, oh, I bought the panels outright, but in actuality, they got a loan from a credit union to buy the solar system, because it was a better return for whatever it is, or rate, or whatever. And they have this misconception that they bought it, and they did buy it from the solar company, but they obtained financing, and so that would have to be dealt with at the same time, because a UCC financial statement for a solar system it can be considered as just like paying off a deed of trust. So just kind of keep that in mind. If the property is held in a trust, depending on how it's read, if it's Ryan and Anna Gettman, trustees of the Gettman Family Trust, different situations, we require a copy of the trust. We don't need the entire trust, because what's in there, besides who's a trustee, who's a successor trustee, anything beyond that is really none of our business. So we do not want the entire trust. We just want about 10 pages of that talks about who the trustees are, who the successor trustees are, what happens if somebody's incapacitated, what happens if You know, so we don't, a lot of, and I don't blame the sellers not wanting to hand that over, because there's a lot of private information in that. So just reassure them, title's just going to need about 10 pages, just the summary of who has the power, what kind of power, so on and so forth. So we will ask for that, and then we will ask for a trust certification on top of that. And it's just for our documentation and what title requires, we have to have a certification with those sellers certifying that nothing has changed. That these people are still the trustees, or these people are still the successor trustees, or there's nothing that has been changed. Your next section is the note section that we had talked about. And so it just kind of rolled, in this case, all note items will not be numbered the same because every property is different. So the notes 1, 2, and 3 in this well, hold on, let me look real quick. Yes, 1, 2, 3, and 4 are, you know, our general notes. 5 is that 24-month chain that I talked about earlier. So item 5 would disclose if there's any activity, any vesting change that's happened in the last 24 months. In this case, there hasn't, but if there was, right under this note, it'll be the details of who the grantor was, who the grantee was, and when it was recorded with the recording information. And then item 6 is if, you know, depending on the endorsements depending on the property, what the endorsements would need to be issued. And item number 7 is that address and type of property that I was talking about. So there was those 2 ones that you're going to probably pay attention to. Again, they're always numbered differently depending on the property, but in this case, item 5 and item 7 would be the items that you'd want to pay attention to. Item number 7 is saying this is what we believe the property be used for single family residence, and then this is what we believe the address to be known as. I need to specify one thing to you that I probably should have noted at the beginning. We insure assessor parcel numbers, APNs. We put the address for what it actually was assigned to by the county. We do not insure zip codes. If you notice, we never, ever, ever show a zip code on a preliminary title report because zip codes change. If you call your escrow officer and said, USPS has this address and this zip code, but you have this, can you reflect this? We reflect what the county has assigned. And sometimes a house sits on a corner and has one address because it sits on a corner, but the county has assigned it a different address. So again, just know that if there's a little bit of discrepancy, please still ask. Again, we're human. We enter data every day, all day, things happen. So still ask. But if we come back and say, okay, and then this is going to lead to hopefully my next slide, which is the map. It's what we have to ensure on our preliminary title report is what the county has. So if you, that Everglade, it's kind of blurry.
It's probably not in Fresno, but it does.
Okay.
It does say Suffolk is the actual street.
Okay, I'm going to go with, okay, so it says Polk and Everglade. Well, I'm going to go with Everglade Drive just for the sake of this. So you have Everglade Drive, Everglade Street, Everglade Avenue. So if you have an appraiser come back and say, or the appraisal says Everglade Avenue and we have Everglade Drive and you're asking us to change it because the appraisal, we are unable to change it because this is an assessor's parcel map. This is what's of record. This map is actually recorded with the county. And the county is saying that this street is Everglade Drive. So unfortunately, you'll have to go back to the appraiser and say, yeah, the recorded map says drive, we have to stick with drive, so on and so forth. Same thing with if somebody says, oh, USPS has my address to say this. So this map is the word of like be all say all. We have to, that's what we're insuring with, and that's what we're showing. So Polk Way, if you had Polk Street or Polk Avenue, we're going to change it to say Polk Way on our preliminary. If you submitted like a contract or whatever, it's going to be changed to Polk Way because that's what the map has. Okay. And then there's just a couple of items, you know, the map and book, page number. It's how the county identifies the entire county, and they break up the county in different pages and different books, just so they assign it their numbers, just their filing type of situation. Disclaimer, and then subdivision recorded map book, that's page number. So when I said it's been recorded, that's telling you this is the recording information. That's the recording information for the map. I think I went over that, but
Yep.
that's a good slide for people that wanted to know about the title insurance. So,
Okay. And then just some things that can go wrong.
same thing, you know, Linda, false impersonation, true owner, you know, not so much the whole situation with Linda and David, but somebody saying they are who they're not really they are. I've had it. I was an escrow assistant, and I notarized somebody that, you know, they came in and they signed their seller documents, and she sat right in front of me and she gave me a driver's license, and I signed her and I notarized her. The license was impeccable. But she really wasn't the person that actually owned the property, and she fabricated pretty much everything. And luckily we got a phone call from the district attorney, like literally hours before we were going to close. So people do that. It's a little harder today to do that. I was an escrow assistant back in 2003. So it's been a while, but it's people that say that they're the owners and they're really not. So that's why we have to collect as much information as possible. Title, one of the things they do is they compare signatures from old documents that have been recorded. So they do a lot. That's why sometimes the title reports take a little bit longer to be generated. So that, you know, we have a big job ahead of us because we need to insure these properties, and we need to make sure everybody says who they are. They say they are, even with buyers. So, and then forged deeds. This is the biggest reason why, when you question, why can't my seller use their notary? Why can't my seller, you know, their cousin is a notary. It's so much easier. Their cousin can go to their house, even especially with COVID, if people were just, this is the biggest reason why we have to use our approved notaries, because our approved notaries have gone through their normal screening of the state of California, but then they have gone through our screening from, you know, through our corporate office, because they have to make sure that not like back in 2003 when I took an ID, and you just have, it's a lot more pressure, but this is the biggest reason why we have to use our approved notaries. Undisclosed missing errors, we're going to be asking those questions, especially when we get a copy of those trust agreements. When people have died, we have to track down, and we have to make sure that everybody that is supposed to be involved in a transaction or has a claim to the property is discovered, and we addressed it. Instruments executed under invalid or expired power of attorney. Power of attorneys are typically, for the purposes of title, typically only good for 2 years, because lots can happen after 2 years. If a power of attorney is older, things could have changed since the last time that they had executed a power of attorney. Mistakes in recording legal time. This is huge. It comes up on a weekly basis. It goes back to like the whole human error type of situation where the APN number, I just had one 2 days ago. Solar company, I had a cash transaction. Solar company recorded their solar agreement on an APN number that they were supposed to record it on 09. prior to our preliminary title report. Misinterpretation of wills. We don't accept wills to validate a seller or a signer of a transaction, but a will can be used to present to the court to determine who will be the actual signer / seller of a particular property and transaction. And deeds by minors. People put their minors on title. They cannot transfer a property. They can't be involved into it in a sale. It would have to go through conservatorship in order for that transaction to go forward. Deeds by persons supposedly single, but in fact married. I just had something similar yesterday. People, they rely on the common law marriage, or they rely on, I got married in another country, and so I married. And so in fact, they're not. And so they're, or vice versa, they are, and they think that if they have a legal document, a certificate, whether it's from another country, they are in California. California does recognize that as a legal marriage, but they're like, oh, I'm not really married because I married him in another country. But if they have a certificate, it's legal. Liens for unpaid estate, inheritance, income, or gift. If we are dealing with a probate, we will be asking these questions. If there's any estate taxes that are due federally, just anything. So if we are dealing with a transaction that has gone through probate, these are the type of things that we will be asking. And if you have a probate transaction, it's just good to know that the attorney will be involved almost throughout the entire transaction. Fraud comes in all forms, one way or the other. Pre and post policy protections, it goes over, that is basically your title policy. Our preliminary is we do date down the transaction, the property right before we record because of that 2-week gap. And then the length of the escrow. So we have to shorten that gap. So anything that comes up at the tail end, don't be upset. It happens. People do go and record things once they find out that there's activity on a property. So it happens. Expanded access coverage, restrictive covenants. A lot of these will be covered if they even exist on your property in the preliminary title report. Building permit violations usually comes up when somebody is already, when there's activity. People go and record stuff when there's activity. And zoning, usually that's when we are identifying something as maybe a vacant land and something has been rezoned as a single family, but it's very rare. Looking through these. These are kind of rare. These last ones are very rare.
So Anna, since we're getting tight on time, I'm going to go ahead and jump to the LiveLook that we send out on our, I believe only our residential properties, correct?
Correct. Yeah, just sale residential. Refis.
Just sale, so not refis either.
Yeah, refis do not get a LiveLook.
And of course, now that one's missing. So hold, please. We're gonna just join a gallery for a minute. This would be a good time if you have any questions about anything that Anna has already covered, just unmute yourself and ask a quick question.
It looks like somebody asked a question. Is there always a lien put on a property if someone owes child support? If the seller is clearly identified and owes child support, we will show child support in the preliminary title report. But if the seller's name is very common and we can't determine that indeed the seller, we'll ask for a statement of information. And then once the statement of information is ran, and that it is determined that it's our actual seller, we will notify all parties that there's an additional lien that we need to take care of. I hope that answered
Okay.
that question.
I believe I'm ready to share. There we go.
So this is, you'll get an email with our preliminary title report, and then this email will show you, this is a summary. And so your summary report, link documents, vesting, legal description, and map. Those are everything that I've gone over, but those, you can jump to that exact section if you use these left-hand links. And then when you actually pull up the LiveLook preliminary title report, you'll have those links as well. But this is basically a quick view of the exceptions. You use your drop down, it'll show those actual exceptions, but these are just your section of the preliminary title report. So you can toggle back and forth instead of scrolling. So basically this prelim is at your disposal just via link, or clicking the sections. Do you have an example of the actual LiveLook prelim, Jennifer?
I don't think that, let's see what happens here.
Oh, if you just click on report, maybe it comes up.
Where is that on
To
here?
the right under summary. Does it come up if you click on the report right under summary? Perfect.
Can you see that?
Yes, yes,
Okay.
yes. So, and then when you get your preliminary title report, and it'll come up over as a PDF. Oh, it went away.
Went away.
So when you open your PDF, you will have these blue hyperlink embedded in your preliminary title report. So if you clicked, I don't want you to click on it because I'm afraid that it's going to go away. If you click on that blue hyperlink that says vested in, it's going to give you the recorded grant deed. So cool. If you click on that, the blue, any of the blue, it's going to give you that map. It's going to give you where this legal description came from, recording wise. If you scroll through, it's going to, if you click on that blue link for taxes, it's going to give you a copy of the tax roll, the tax bill. How cool is that? And it just goes on and on and on. So if you want to know what that exception is about, and you want to see what that recorded, because you have to understand our preliminary title report is a summary of the recorded document. If you want to read further into the actual document and find out what the content is, what it's about, more detailed, click on that link and it comes right to you.
And that's basically everything. So, and of course, the red is matters that definitely have to be addressed before closing, and the yellow are things to take a look at when you see that.
Yes. So green is good, red is bad, and yellow is like, don't panic, we're fine.
And we had a couple more questions in the chat, and then we'll be ready to wrap up. Just in general, once people have submitted an SI, and we are for the most part just looking for SIs on sellers these days, but they will also be looked at for anyone refinancing. How long is that taking, Anna?
I submitted an SI yesterday morning, or I'm sorry, Wednesday morning. And by the time I got into the office, I'm sorry, Tuesday morning, by the time I got into the office Wednesday morning, title had responded to me on my SI. So it's about 24 hours.
2014.
Okay, somebody needs to mute.
We have a 2014.
It's Atef Zenai. There you go. And so, and just to kind of piggyback on what you said, it's mainly sellers. We do ask for SIs on buyers for the purpose of federal tax liens, and bankruptcy. Any abstracts, any child support, we are moving past that. So I know in the past we used to have to deal with all of that, but buyers, if their name is very common and we are seeing federal tax liens and bankruptcies, those are the two items that we will have to deal with the buyers.
And then we had a question that if you are doing seller financing, seller carrybacks, what type of title insurance does the seller receive on their financing?
It's called a joint CLTA protection. So it's equivalent to the actual owner's policy, but it's insuring the seller that's deeding out and carrying the note as an additional insured.
And that actually came up on another escrow last week where we had somebody believe that because they had done seller financing, they still owned the property until the buyer had paid for the property. And that's not the case.
That
It's
is not the case.
everything is deeded to the buyer. And if they stop paying, you are required to go through the foreclosure process in order to get your interest in the property back.
Correct.
And then somebody just wanted to confirm that the power of attorney can be no older than 2 years for use in a property sale.
Correct. And the reason being is things can change, especially if the person that is giving the power of attorney has fell ill. And just situations can change. Military is power of attorneys are the only exception, because somebody can be deployed for more than 2 years.
All right. Well, thank you, Anna. I think that's all of our questions. Again, we will send this recording and some supporting documents out to everybody that registered. Thank you for attending today. And also, you can always find the videos on our YouTube channel at Chicago Title Fresno. Also, we have a Facebook and an Instagram. We post all of our classes on that Facebook page and try to mention it on Insta as well. Those are also under Chicago Title Fresno. Anna will also be teaching our next class coming up on May 6th, which is dealing with escrows involving corporations, partnerships, and LLCs. There's just a few little special things about those entities that we want to make sure you as realtors and lenders are aware of. So if you have any questions at all, don't hesitate to reach out to Anna or to your sales exec or to me. Thanks again for joining us and have a great day.